Hello and welcome to another TDW Tech Bite. This is Padraig Walsh here at the Corporate Commercial Department of Tenor DeWitt, and today we're going to speak about mandatory data breach notifications. We're going to cover 4 topics within the next 5 minutes or so. First, we're going to speak about the current position in Hong Kong. Then we'll speak about what others are doing elsewhere in respect of this topic, how the rules are going to change in Hong Kong, and what your next steps should be as a business. So let's crack on. First, what's the position right now in Hong Kong? Well, there is no legal obligation to make a mandatory personal data breach notification to the Privacy Commissioner or to the affected data subjects. That's the position. It's not that there are no guidelines out there. The Privacy Commissioner has issued guidelines on this topic, updated them as recently as 2019, but those are non-binding guidelines. And to give you a sense of the impact of this, in a very recent significant data breach, for which there were 9.4 million affected data subjects that occurred in Hong Kong, the Privacy Commissioner in his investigation report commented on the fact that it took 7 months for a voluntary personal data breach notification to be made to the Privacy Commissioner, but still made no adverse finding because it didn't break the law. But the writing was on the wall. Things needed to change. So, what have others been doing elsewhere? Well, let's look at the gold standard. The gold standard globally is the rules that are in the EU under GDPR. And there, a mandatory data breach notification must be made as soon as feasible, but in any event, and not later than 72 hours after the data breach is identified. 72 hours. Not even working days, just hours. 3 days, and you have to let the supervisory authority know. And there's prescribed information that you need to deliver in that notification. And frankly, you wouldn't be able to deliver that information within that time frame unless you have systems, policies, and procedures in place to equip you with the information to be able to do so. And that's part of the reason in GDPR why there is such a strict time frame. The strict time frame is there to encourage, almost mandate, privacy by design principles. Because without that system in place, you will not be able to give the information needed within the time required, and you'll find yourself in a world of hurt. Is the EU the only place that has mandatory breach notification requirements? No, it's actually fairly common across the world. And even where it's not common, the rules are beginning to change there also. So for instance, there are changes to the laws being proposed in Singapore to bring in a mandatory personal data breach notification to the commissioner there. So what does this all mean? Well, what it means is that here in Hong Kong is now part of a converging trend towards a system of data breach notifications that is similar to or comparable with what is required under GDPR in the EU. And the Privacy Commissioner has brought forward those proposals. Let's look at what's being proposed in Hong Kong. Firstly, the definition of what will require or trigger a mandatory personal data breach notification has been identified. The standard will be a data breach which gives rise to a high risk of significant harm. And let's look at those words a little bit. A high risk of significant harm. The first thing to note about it is that it is the same standard that is going to trigger a data breach to the Privacy Commissioner and to the affected data subjects. And it's to the higher standard. It has to be a high risk or real risk of significant harm. Now, that's not the case in the EU under GDPR. The trigger notification for notifying affected data subjects is a higher standard, but basically there's a default position where if there's a risk of harm, then that must be notified to the supervisory authority. So that's one of the changes that's about to be brought in. The other change that will soon be brought in is the time frame. Now, the Privacy Commissioner in Hong Kong has suggested that the time frame should be 5 working days. That's still an aggressive time frame. It's not as aggressive as 72 hours. But I think what you can fairly say is that you will not be able to make the report with the information that will be required unless you have the systems, policies, and procedures in place to equip you with the information to do so. And that brings us on to the steps that you should take to prepare for these changes in the rules. And those steps are, let's repeat the phrase, you need to get your systems, policies, and procedures in place. That requires a combination of skill sets. Yes, you will need your lawyers to prepare policies and procedures for you or to oversee them. But you will also need other kinds of experts, IT experts, who will be able to audit and assess your systems, do data mapping exercises, and really do an assessment as to what data you collect, where you store it, how secure those systems are, both in when they're static and stationary and when they're in transit, and all the other cybersecurity issues that go with it, because it's the cybersecurity risk that links into the data breach. So your policies, your training, your education, your audits, your implementation, your assessments, all of these steps need to be looked at and put in place now because these laws are changing. Change is in the air. We can help you here, but that's a summary of the changes that are likely to be brought into law in Hong Kong in the next couple of years around mandatory personal data breach notifications. Tune in next time for another in this series of TDW Tech Bytes on the changes in personal data privacy laws in Hong Kong.